Miller is appealing his convictions of felonious assault and tampering with evidence in this matter. I'm sorry, but Mr. Miller has raised one assignment of error in this matter, that the convictions here were against the manifest weight of the evidence. I think the record speaks pretty clearly for itself. There is conflicting evidence. There is some audio that is played regarding...
Excuse me for interrupting you.
Yes.
I found this brief rather conclusory. I have very little recollection of facts that would assist us.
And I'm very sorry.
And if you could give us a short statement now.
I would be happy to. The evidence, as presented by the state, the argument is that Mr. Miller was over a family and friend's house on the evening in question, and proceeded to an argument ensued. I don't think that those issues are in dispute. Mr. Miller is accused of having left the house, returning, yelling at people, firing a firearm in the yard, and then the police are called. Mr. Miller is alleged to have run off. There is there's a 911 call that is played where shots are heard and some people are heard yelling, but Mr. Miller is not identified in that by voice or any other, or by name in that call. The police arrive, they search the area, they find a gun hidden in a neighboring area under a bush, and they also find Mr. Miller in a garage. There was at trial presented several witness testimony as well as an expert purportedly testifying that the gun casings found in the yard matched those of the gun which was found under the bush. At trial, the trial counsel, and this is one aspect of this that I really want to focus on, did a exemplary job on cross-examination of demonstrating the lack of scientific basis for the BCI experts' testimony regarding the gun casings, the limitations in that, the rather conclusory nature of that analysis, the fact that...
Conclusory in what respect? He had the guns, I presume he looked at them, or the gun casings, he looked at them under a microscope and said what he said.
In terms of being a scientific analysis, there is no... Certain things are lacking from that analysis.
Well, what certain things, and why are they prejudicial?
First of all, there's no clear explanation of how they reach that controls. The slides, the reports are not of how they reach the conclusions. As trial counsel talks about in a fingerprint analysis, you can point to 20-point, 30-point confirmation.
But
Here,
these are bullet cases.
there's nothing in a bullet casing that confirms. There's no analysis of how they reach why this is the same. There's also no control group. There's no, unlike in a DNA case where you have the DNA and you then put it out against a giant database of other people, you're essentially given a gun, you're given a bullet, and you're saying, are these the same?
And people who do this work will look at the back end of the bullet and the strike mark and other striations and say that that bullet was fired by that gun. I'm presuming that that is the evidence that was presented, but you don't exactly say in the brief.
And it is what is presented, and in that analysis also there is a great deal of challenge. There is no, and as you said, there's one gun fired, there's one casing compared to, which is not...
Tell me what's wrong with that, or unfair, or error.
There's not 100 guns fired, or 1,000 guns fired, or a population of guns fired, and then you say, this is the gun that bullet was fired from. There's one gun, and essentially it's a yes or no question, and you don't have error controls as to whether some other gun would match that striation. There's an assumption made that this is the right gun,
But
that this
based
is
on
the
the
same gun.
evidence, he had one gun.
That's the point, but did he have that gun?
That's not disputed, is it?
No. I
So
mean,
why do we
the
have
evidence,
to
well, the
test-
evidence is disputed whether it's his gun or not, under the shrubbery.
Well, that's a
not
different
perfect,
issue
but-
from,
but-
from the ballistics report.
Yeah, but that is the issue, was that one gun necessarily the gun that was
Well,
fired?
that's a question of fact for the jury, based
And-
on the
That-
events and the testimony, correct?
Absolutely, but you're also, and that's the point, is that when you're presenting expert testimony, or what is presented as expert testimony, that is highly suspect as to its value, because,
Where's the expert testimony and somebody saying, I saw the man with the gun and he shot,
no, I'm talking about the expert who appeared
okay?
because,
The expert who testified the bullet matched the gun.
right, and that expert did not, he had only one gun to choose from, and he has purportedly never been wrong. He has purportedly always been confirmed when the same gun is tested. I'm saying that there is a flaw in the method, in that you can't exclude other guns by simply looking at one gun. That is one of the primary issues here, that you are looking at it would, unlike DNA, unlike fingerprint evidence, where you can look at a massive number of guns, or fingers, or people, you're not even presented that broad range to say, there's no exclusion here, unlike in a DNA test where you say, I'm looking at this person, and you then see this literally astronomical number with 10, 20 zeros after
So
it,
you're.
to say there's a 1 in X thousand chance, X million
So
chance
you're really
that this could be someone
You're
else.
challenging the methodology of matching the strike mark on the bullet casing with the hammer of the gun.
And I think that was very successfully challenged at trial.
And
To the
I
extent that-
apologize, I forgot to start this, so
Okay.
I'm not sure how many minutes you
I
have.
will
but
not,
We're not
I
waiting.
promise I won't keep you much longer.
No, I don't want to cheat you, but I just wanted to.
No,
let you
and,
know that I wasn't sure where we were.
And I think that is, and I think that without that evidence, or with that being presented, as that creates a great deal of bias there, and I think,
So
that
how-
without that evidence, I think you're left with conflicting witness testimony, as to what happened on that night, who left the house, who was yelling at who. And I think that at that point, you have trouble getting to beyond a reasonable doubt. I think it had to be that they relied on this expert testimony, well, that was the gun which was found in close proximity to Mr. Miller, and therefore, he must have been the firing party. And, I think that without that testimony, you don't get to